What's happening, gang? You are live back in the Secret Stash. I'm your host, Jesse Ibañez, tracking down some of the coolest local people, talking about some important local stuff. And in the Stash live today with Kenneth Stone, owner of Stone Law Group. We're talking about real estate because that's what we do down here at the Greenhouse Group. That's my firm helping folks get into and out of homes and moving people with purpose. You can see who we are and what we do, as well as all of our featured listings. By the way, Ken, we got two that are coming up this weekend. One up in Rancho Penasquitos, one down in Bonita. And those are two fantastic purchase sale prices compared to the rest of those in the neighborhood. So I know you got somebody for us over there. Make some happy sellers. Or who knows, maybe it's somebody you know. Go down and check us out at thegreenhousegroupinc.com. See if that'd be a right fit for you. Speaking of the right fit, this whole concept of two parties getting together on either side of a real estate transaction. Okay, sometimes it doesn't quite go as planned. And that's when you got the whole real estate litigation thing, the four-letter word, you might say, if you can cram it in there, that no one wants to deal with at the dinner table. So we got Ken Stone in here, owner of Stone Law Group. You can catch him, by the way, at thestonelawgroup.net to talk about how to avoid it and how to deal with it. So we've hashed out the concept of, what are some of the top hit singles, you might say, things that you've noticed, Ken, over the last several decades that seem to happen consistently over and over again. We hashed through some of those. We also talked about some ways that buyers and sellers can avoid litigation, respectively. Inside the weeds of the contract, there's this whole thing on mediation. Now, if you've bought or sold a home, you know what I'm talking about. It's the big, bold letters buried in about page 6 or 7 of the contract, right? So help us understand what that whole thing is about, Ken, and maybe share some of your experience around it.
Well, there's a provision that there's two provisions, a mediation and an arbitration provision. The arbitration provision requires both the buyer and seller to initial it in order for them to be bound by the arbitration provision. The mediation provision applies whether or not the parties agree to arbitration. And what mediation is opposed to going to court and having a judge decide a case or going to an arbitration and having an arbitrator decide a case. Mediation is a voluntary process where the parties usually sit down in a confidential environment across the table from each other with a neutral third party who acts as a mediator. It's usually an attorney or a retired judge, and they have a discussion about their respective problems, and they see if they can resolve the matter. And it's really an important feature in contracts, and the real estate purchase contract encourages the parties to mediate by actually putting a provision in the contract that provides that if one party does not agree to mediate prior to going to court or to arbitration, that they lose the right to recover their attorney's fees and costs in the event that the case is ultimately litigated. So it's really it's important that the parties make that effort, and many of the cases do get settled at mediation.
So, and I don't want to gloss over that because you said it. You're inside the mastery, classic race from the runners scenario, but there are two initials inside of that page. One's for liquidated damages, the other one's mediation arbitration. If you fail to or knowingly actually choose to omit your initials from those two, you're actually forfeiting your ability to what?
No, you're not forfeiting your ability. In other words, what I meant to say, if I wasn't clear, is even if the parties don't initial the arbitration provision, they're still bound by the mediation provision. So in other words, if the parties decide if there's a dispute they don't want to go to arbitration, they're going to resort to the courts, they still have to go through the mediation process first, or the party who refuses to will forfeit their right to recover attorney's fees and costs.
I see. Got it. Okay. Thank you for clearing that up. I think I was the one that was unclear. I think you said it perfectly. Okay, good. So then, like, for example, that whole concept of mediation, like what's that look like? Like, is it like, because everybody knows the whole classic courtroom scene kind of thing, right? So what's mediation look like? Is everybody hugging and tapping each other on the shoulders and stuff?
Not exactly, although it tends to be a little more humanistic than a courtroom environment.
Not a bad thing.
Yeah, and generally, if you're in litigation, the court can even refer you to mediation, or you can go through a settlement conference with the court. The difference is that oftentimes in a settlement conference in the court, the judge who hears the settlement conference has his own calendar and oftentimes doesn't have a lot of time to really digest what the case is about, and sometimes does not have the time to facilitate the same kind of settlement that can be accomplished at mediation. Mediation
That's an interesting point. You're going to need another ding for that, because that is a challenge. Somebody who might be really good at what they do, they don't have the time. They're just going to default to what they've always known.
Right, because judges have their own calendars, and they may set aside an hour for a settlement conference, but that may be all the time they can spare. Where with a mediation, oftentimes it'll take, generally mediations are scheduled either on a half-day or a full-day basis, and going in, oftentimes clients don't realize that it's going to take as long as it really takes, but it's a process, and it's a process of dialogue across the table, and then there's shuttle diplomacy where the mediator goes back and forth between the parties privately, and it can take a whole day to get a case settled sometimes.
I'm surprised to hear you say that it's usually only a day, though. I would have expected that to be drawn out longer than that.
Well, sometimes it can be done in a half day, and sometimes it takes a whole day. It depends on what the issues are, how many parties are involved. If you have multiple parties, it's certainly going to be a longer process. But usually the mediations take between a half day and a day. And it's informal, so you don't call witnesses like you would in an arbitration or a court proceeding. Everybody signs a confidentiality agreement, so it promotes a freer exchange of information. And oftentimes, even if the case doesn't get resolved, the parties go away with a better understanding of each other's positions, so they sometimes develop a little more respect for each other.
Boy, you'd hope so. Or they would just dig down into why they hate the other person deeper.
That happens.
That's their choice. Too. Yeah. Good. So you had mentioned, I guess, the concept of time, right? So maybe we could play that out into all these different facets or arenas. Like, so what would somebody expect? I mean, we've heard maybe the vote on the mediation concept, but what about for the other options?
Well, there are advantages and disadvantages to the arbitration provision.
Okay.
The advantage of arbitration is it's a more streamlined procedure. So the ability to conduct discovery is more limited. You generally get your case arbitrated faster than you would get it to trial if you filed a lawsuit.
Makes sense.
It can be a little less expensive on the attorney's fee side, but it can be more expensive on the cost side because you have to pay for your arbitrator's time, where in court you're paying a filing fee and you don't pay the judge by the day if you end up in a court trial.
Interesting.
And the other nice thing about arbitration is it can usually be scheduled to the parties' mutual convenience and the convenience of their lawyers. So if you determine a date the case is going to be arbitrated, it's going to be arbitrated that date. Where in a court proceeding, generally trial calls in San Diego are on Fridays, but you could go in on Friday and find out you're not going to start your case the following week because the judge is already in trial in another case, or sometimes you have to wait more than a week before you start your trial. So the advantage of arbitration is convenience. The disadvantage is, well, you don't get a jury. You lose the right generally to appeal. So that there are advantages in the court system, and you lose the right in arbitration to conduct the full breadth of discovery that you get to do in a regular civil case, which would include written interrogatories, depositions, things of that nature.
And the brevity, I'm sure, is well designed for the format, right? Because the concept of, for example, you said a judge versus a jury, like, you know, the judge, I would imagine, or the person who's arbitrating, I should better say, is going to be kind of following more the book, so to speak. Like, right, there's going to be interpretations of each side, of course, but more it's going to be like, here's how it's sort of written and very slight interpretations. Whereas when you're dealing with like a jury, it's full on what people think and feel. And
well, with an arbitrator and a judge are generally going to they could be the same kind of people, because oftentimes the arbitrators are retired judges. Right. But arbitrators have a little more leeway in terms of rules of evidence. There's a little more liberality. In a court proceeding, if you opt for a jury, you're getting 12 people who are generally going to make an informed decision based on the evidence they hear, but it usually takes longer too.
Right. You hope so. Right. And a lot of variables in that capacity too. So, you know, inside of a typical real estate contract, gang, you may or may not have even noticed this, but there's definitely this in big block, bold letters. And so when you are initialing those, and this is something that's interesting too, is that when you send somebody over a contract, like we use DocuSign, you know, it's really fancy way to get things done quicker. You know, they identify who their identity is online, and then they can just click, and it basically populates your signatures and initials respectively in the contract. Those two are the optional ones, to where you actually have to go in there as a buyer or seller respectively and click it. It's like it doesn't default to it as a mandatory thing. And that's an interesting thing, because what I heard you say for the first time is that even if you don't click the mediation, arbitration, right? You're still it's still the first round of interaction, so to speak, a first round of defense. The first modus operandi is you're going to be going through that process, whether you clicked it or not.
That's right. And in fact, I think the local boards of realtors provide mediation services for that provision.
Yeah. So something that you don't ever want to get into, but good to know, my man. And that's why we got Kenneth Stone in the house, Stone Law Group. By the way, you can catch him at thestonelawgroup.net, or I'll give your number one more time, Ken. It's 619-233-1818. So coming up, Ken, rounding out this conversation about real estate litigation, how to avoid it and how to deal with it if it happens, we're going to drop perhaps the most telling or important lesson of all. I'm going to put you on the hot seat for, drawing your experiential capital of wisdom for the last several decades and say, what's the one thing that you've learned that you're going to leave Stash Nation a little better than how you found you? We're going to drop that as a tease, and we're going to see you right back here on the other side of this break. Real Talk Radio San Diego. Thanks for hanging out.